So we have attendees starting to join. We have about 60 people we're expecting today. So welcome again to everybody who's registered for today's webinar. Its topic is how to seize $1 billion, which we have some presentations and some special guests with us today. My name is Ihor Mekhatishin. I'm the Executive Director of the Ukrainian Canadian Congress here in Ottawa, and we're pleased to co-host this presentation with the Ukrainian Canadian Bar Association. We are going to give all of our registered guests just another minute to pop into the call. If you do have questions throughout the presentations, throughout the session today, we encourage you to use the Q&A button function at the bottom of your screen. You can type in your question, either as a general question or a specific question to one of our guests presenters. And we'll have time following the presentations to look at those questions. So we encourage that. And we have a number of presenters today who have some interesting information to share with you. So again, without further ado, I'm going to turn it over to Alesia Nahirny, the president of the Ukrainian Canadian Bar Association, to introduce our special guests and to get the program going.
Thank you, Ihor, and good afternoon, everyone. It's my pleasure to welcome you today to our webinar on asset recovery. We are very grateful to have our distinguished speaker, Maria Nizzero, who is here to discuss her most recent research and report, How to Seize $1 Billion, Exploring Mechanisms to Recover the Proceeds of Kleptocracy. The report essentially examines the range of established asset confiscation concepts and their operationalization in specific jurisdictions, with lessons that we can take away for Canada and the UK, as well as other countries. A key question when reading the report that I thought Maria is trying to answer is, how can we establish an effective asset forfeiture regime in relation to sanctions-based asset freezes? And what mechanisms can enable governments to achieve permanent confiscation of assets linked to illicit finance, while also ensuring that we are giving due consideration to human rights and the rule of law and due process. So I will introduce Maria. Of course, she is a research fellow at the Center for Financial Crime and Security Studies at the Royal United Services Institute, the world's oldest, in fact, and the UK's leading defense and security think tank. Her research examines the UK economic crime landscape and asset recovery with a focus on sanctioned frozen assets and proceeds of kleptocracy. Now, prior to joining RUSI in 2021, Maria worked for a London-based agency specializing in financial crime, and then previously for a financial news company, Dow Jones. So welcome, Maria. I would also like to introduce our second speaker, Professor Van Hampton. Professor Hampton is the president of the World Refugee and Migration Council, Chancellor's Professor and Professor of International Affairs at the Norman Pattison School of Public Affairs at the University of Ottawa. He holds a PhD from Harvard University and is the author of 15 books. Professor Hampton and the World Refugee and Migration Council have been instrumental in advocating for the establishment of an asset forfeiture regime in Canada and for the repurposing of assets to aid, among others, refugees and migrants. So it's a pleasure to have you with us here, Professor Hampton, and I look forward to hearing your perspective on Canada's asset forfeiture regime and in fact, its effectiveness. And finally, as Ihor mentioned, we will then go to our Q&A section, and I will invite my colleague and fellow Asset Recovery Working Group member, Alana Skotchmer, to lead us through the QA portion of the webinar. And so please do have your questions ready, type them in as they come to mind, and we will we'll certainly make best efforts to answer them. Now, before I hand it over to Maria for her presentation, I just wanted to level set and give a brief overview on the Ukrainian Canadian Bar Association and the Asset Recovery Working Group and the work that we've been doing in the last year. So we are essentially a group of lawyers that are interested in supporting Canada's asset recovery efforts with the aim of repatriating funds to help those affected by breaches of international peace and security, human rights violations, acts of corruption, The group was set up immediately after Russia's invasion of Ukraine in February of last year with a view of helping Canada establish an operationally effective asset recovery regime. It consists of lawyers that specialize in asset recovery litigation, human rights, anti-corruption, anti-money laundering, and sanctions. So when the group was formed, initially we became aware of a piece of legislation that was making its way through the Senate, and that was Bill S-217, an act respecting the repurposing of certain seized, frozen, and sequestrated assets, which was sponsored by Senator Almodovar with the assistance from the World Migration and Refugee Council. And it essentially established for the asset forfeiture regime in Canada. Now, the group at that point took the legislation and was tasked with looking at it from an end in mind, right? If we were to enact this legislation, would it be operationally effective? And the asset forfeiture litigation lawyers were particularly engaged to provide their feedback. We also looked at civil forfeiture legislation in the various Canadian provinces, such as the Civil Remedies Act and the Civil Forfeiture Act in Ontario and BC, respectively, which allow for Attorney General to freeze, take possession, and forfeit to the Crown property that is determined to be the proceeds of crime or unlawful activity. So the intention was to, as the legislation was making its way through, to look at existing legislative frameworks to see how they might be leveraged for the purposes of designing an asset recovery regime tied to Canada's sanctions framework, and that would allow Canada to meet its foreign policy goals while also adhering to the rule of law and due process principles. Now, similarly, and as some of you may know, the Budget Implementation Act came out and essentially had provisions in there to change Canada's sanctions legislation and put in place the asset forfeiture provisions. So Senator Almodovar's bill did not proceed, and in fact, we pushed that legislation through the omnibus bill. But again, our group, with the limited time that was given, tried to analyze the legislation with the operational effectiveness perspective in mind. You know, would this be a legislation that could immediately take effect and be used and be effective in what it was trying to achieve? Now, suffice it to say, the legislation moved through very quickly. We didn't have an opportunity too much to discuss a lot of the recommendations that we had. So the group strategically made a decision to focus on ownership and control, and definitions of ownership and control, or the lack thereof, in the Canadian context. And that's kind of what we put forward as a recommendation to Global Affairs Canada, members of Parliament, the FINA committee in the House of Commons, and members of Senate. So a lot of work was done we were trying to do a lot of work at the front end to design the regime in a way that would be effective. But unfortunately, because the legislation was being advanced so quickly, there wasn't too much time to do that. So where did we end up, and what do we have now in Canada? On June 23rd, 2022, Canada became the first G7 member to implement an asset forfeiture regime that is tied to its sanctions regime. So our Special Economic Measures Act and our Justice for Victims of Corrupt Foreign Officials Act, the Magnitsky legislation, were both changed and gave the government powers to seize, forfeit, and dispose assets held in Canada by sanctioned individuals and entities. And not surprisingly, the amendments were in direct response to Russia's invasion of Ukraine and Canada's commitment to work with allies to find, restrain, seize, and confiscate, and then forfeit the assets. And it was indeed a part of Canada's effort to strengthen its sanctions implementation efforts as a whole. So I will just touch briefly on the provision in both. It's similar in both pieces of legislation, and that is that the forfeiture powers and the forfeiture regime is such that on the application by the Minister of Foreign Affairs, The judge shall order that the property that is the subject of the application being made be forfeited to the Crown if the judge determines, based on the evidence presented, that the property is essentially described in the order and is owned by the person referred to in that order, or is held or controlled directly or indirectly by that person. So as you can see, the provision and then the legal test it's quite simple. And you will note that this is why we focused on ownership and control held directly or indirectly, because it's a very key part of the legal test and for the application by the minister for the seizure procedure. So what have we seen since then? These powers were enacted. We're coming up to about a year. And what kind of developments have we seen in Canada? On December 19th, 2022, the Honorable Melanie Joly, Minister of Foreign Affairs, announced that Canada will pursue forfeiture of 26 million from Granite Capital Holdings Limited, which is a company owned by Roman Abramovich, a Russian oligarch, who is a designated individual under our Special Economic Measures Act. And this would be the first time the government would use its new asset forfeiture powers pursuant to the legal regime that was enacted in the summer in June 2022. That said, we haven't seen any further developments on this announcement. To my knowledge, there's been no application by the minister to the court to seize and forfeit the property. However, we have had Canada recently published its 2023 federal budget, which indicates an intention by the government to establish a Canada Financial Crimes Agency, which would bring expertise necessary, among others, to increase asset forfeiture results in Canada. There's also an expectation that the Budget Implementation Act, which is soon to be tabled, I understand, will provide more detail as to the further legislative changes that will be effectuated to operationalize Canada's asset recovery regime. In the meantime, and you may have seen in the news, Canada seems to have agreed to hand over the Antonov AN-124 aircraft, which has been sitting in Toronto's Pearson International Airport for the last year, to Ukraine, right? So this is a plane that's owned by the Russian cargo company Volga-Dnepr. The news was made following the recent visit of the Prime Minister of Ukraine, Denis Shmyhal, to Canada. It should be noted that Volga-Dnepr Group and the Volga-Dnepr Airlines are both listed as designated entities under Canada's sanctions legislation. And so it will be interesting to see how and under what legal parameters and the legal regime will this plane in fact be seized and sent back to Ukraine, as has been announced by the government. Now, this is where I would just take a moment and refocus on what is the purpose of this particular webinar. Why is it that we're interested in speaking with Maria and very excited about her research? As I said, the asset forfeiture regime established in Canada is soon to be reaching its 1-year anniversary. However, we're not really seeing effective implementation of it. And why is that, right? There's certainly high demand for advice on policy and design aspects to the regime, I think both in Canada and the UK. This webinar is then meant to assist policymakers by presenting relevant research and expertise that could help facilitate those discussions, and in particular with respect to devising an operationally effective asset recovery regime. You know, what can we learn from the UK? What is the UK doing? What can we learn? What can the UK learn from Canada? Those kind of cross-regional discussions are very important. This is an uncharted territory, and it's very valuable to have researchers like Maria who think outside of the box on what is possible rather than what is, because that's where we need to be doing the thinking. So that said, I am very pleased to be welcoming Maria Nizzero as a presenter at today's webinar. I look forward to your presentation, Maria, and it's over to you. Thank you for being here.
Thank you, Alesia, and thank you very much for the kind words. I hope my research actually is as useful as you presented it. So first of all, thank you for having me. It's a pleasure to speak to you all. And I think I'm actually even more excited to speak to you today, because most of the times actually when I talk about my research here in the UK, actually the first question that I get is, what is Canada doing? What about Canada? Because we heard about Canada and we heard about, the different measures that have been adopted. How is that going? Can we be a bit more like the Canadians? So it's interesting to see that actually, it's important to have a conversation because people are asking each other the same exact questions. I thought it would be good. I will try to be quite brief with my presentation. Please tell me if you see my second slide. I am not seeing it. Can you see it by any chance?
Not at the moment.
Not at the moment. That's great. Okay.
Now we see it. Now we see it.
Right. Okay. So it might catch up at some point. So if you see 5 slides altogether, just let me know. So I thought just for my presentation to give a brief overview of how I got where I am right now, because basically this paper, which was funded by the FCDO, like a program, it's called the Socrates program, and it's about serious and organized crime, and now obviously focuses as well on illicit finance, and it was funded, it's partially funded by the Foreign Office here in the UK. So there was quite of an interest by UK policymakers in understanding this matter of how to move, and as I put it here, from freeze to seize. This is a sort of a buzz phrase that has been repeated since basically Russia's further aggression against Ukraine in February last year. And as you can see, it has made the headlines, especially in the UK and in the US, but I've seen lately also, obviously, with European partners, they have actually set up in Europe a freeze to seize task force. So what does freeze to seize means? So after Russia further invaded Ukraine, Western allies, UK, US, Canada, everybody was very quick in the rolling out of sanctions. We started hitting individuals and entities allegedly linked to the Kremlin, freezing their assets. However, with the freezing of the assets, it came a sort of realization, well, or rather 2 realizations. First of all, once the assets are frozen, they stay in a frozen limbo forever until sanctions, in theory, are lifted. However, do we want to get to that point in which sanctions are lifted and assets are simply returned? We've seen it in other cases, for instance, in Libya, that actually happened with some of Gaddafi's money. So we have that one question. And then on the other question, when we look at the list of the individuals who have been sanctioned, well, some of them they are the so-called oligarchs, who I really don't like the word, but it basically identifies individuals who, through corrupt practices over the course of decades, they have amassed and they have plundered their own countries, so Russia and obviously the neighboring former Soviet Union countries, but they have plundered this money and they've stashed that money and those assets in other countries, the UK in this case, obviously being the focus of my research. So we should have got those assets long time before the war in Ukraine broke out, and we should have actually going after these individuals, because dirty money, as the former Home Office Secretary Priti Patel said, there should be no place to hide, nowhere to hide for dirty money in our countries. So this is basically the representation of the freeze to seize phrase. So how do we achieve permanent confiscation of assets that are currently frozen under sanctions? Oops, now it's going too fast. Now, I thought I would divide my presentation a bit in, so I'm trying not to be too technical, but I'm also expecting people to be a little bit aware with the conversation. So just let me know if I'm being overly either simplistic or overly technical. But I thought it would be good to divide this whole issue in 3 different issues. So on one side, we have the what. So what are we talking about? Which are the assets that actually we're trying to confiscate? Then there's going to be the why. So why are we doing this? Why are we even talking about that? And finally is the how, which is the focus of my research. So if we want to get these assets, how do we do that? In terms of the what, I think that the very first distinction that we have to make, and you made it a bit in your presentation, is the fact that when we talk about sanctioned assets, we're talking about state assets and individuals' assets. So for both cases, different issues arise. So we have the state assets, mostly, obviously, we think about the central bank assets. They are the biggest chunk, which every time that somebody asks me about the reconstruction of Ukraine, I'm always redirecting people towards that chunk because I think it amounts now more than 300 billion. So it's big. That is what we want if we are to reconstruct a country properly. So that is the bigger chunk. Obviously, with the state assets, specific issues that I'm not going to dwell too much because it's not the focus of my research, but issues such as sovereign immunity, international law, due process as well, they all arise in a way. On the other side, we have individuals' assets. So all these individuals who have been placed on designated lists because of their supposed affiliation with the Kremlin. It's a smaller, still significant, because I wouldn't mind to have that money, but it's still a smaller chunk in comparison to the state asset one. Confiscation in this case, personally, I think it would be more symbolic unless we are thinking of those assets as proceeds of crime, and therefore there would be for like a criminal justice purpose that we are serving. And in that case, we have other issues that arise, mainly related to human rights and due process. This is for a main reason. Sanctions themselves, it's the same in the UK, obviously, as in Canada. Obviously, I'm going to focus from talking about it from a UK perspective, but sanctions, generally speaking, they rely on a very low standard of proof. Actually, here in the UK, there was a case a couple of, I think now it's basically a month ago, in which it was actually decided and ruled, the court ruled that even hearsay and allegations can be used as an evidence for designating an individual as a person of interest, so a person of significant control. So obviously it's a very low standard of proof. The type of evidence that is provided for this designation cannot be presented, it cannot be submitted as evidence in court. It would not stand because it goes even lower, the different basically standards of proof that would be normally allowed for confiscation recovering processes. And finally, and I think this is quite the important part that led the UK not to follow the Canadian path, which is the fact that when you have a sanctions designation, significant deference is granted to the legislature by the judiciary. So you have an individual, in your case, it would be, I think, the Secretary of State or Ministry of State, who ends up making that final decision, leaving it to a politician, leaving to a political decision, something like asset recovery processes, which are a criminal justice issue. That is the first, strain when we talk about protection of human rights, property rights, even presumption of innocence, and so all the different aspects of due process that we need to consider, regardless of who the person is. So this could be applying, these apply essentially to any assets held by literally whatever individual, to you and I, and even the oligarchs. So this was the beginning of my research. We started from the assumption that sanctions cannot be used as a starting point for confiscation, which also led basically us to say, okay, so we know about the Canadian model, we're aware of it, but we're not going to go down that route. Some people in the UK have proposed some similar bills. So far, they haven't really gone anywhere. One was presented in Parliament, but it really stopped there, and it focused on state assets again. It didn't focus on individuals' assets because of these issues that I have highlighted. So the second thing, the second issue that I would say is the why. So it comes again another question. You said it very well in your presentation. When we talk about sanctions, we're talking about a tool that is a foreign policy tool. Sanctions are a tool that is aimed at changing behavior. Obviously, it's a tool of economic warfare, essentially. So when we talk about asset recovery processes, instead, we're talking about criminal justice, which is a completely different thing. So if we talk about freeze to seize, if we talk about achieving this permanent confiscation of sanctioned assets, then we need to ask ourselves, why do we want to do that? Is it because we're trying to hold the oligarchs accountable for Russia's atrocities in Ukraine? Is it even an offensive measure against Russia, if we think about the state assets? Or is it because we're trying to hold the oligarchs accountable for their historic corruption? We probably are all aware that most of the oligarchs amassed this wealth. They started at least in 1990s during the collapse of the Soviet Union. So that is serious historic corruption that is very difficult to prove. Or considering, the corrupt practices that these individuals are still, most of them are still involved in, is it because we want to hold them accountable for their current association to what could be considered a kleptocracy? So we know, and we often say that Russia is currently in a state of kleptocracy, which was very useful for instance, the fact that right now the military is not as where it's supposed to be because of the endemic corruption. But at the same time, this elevates potentially the country to the status of kleptocracy. So depending on where we focus and depending on the why, that's where we have to develop different mechanisms. So I started by saying, okay, so what is the crime that we're focusing? Is it the crime that happened there in Russia and happened then, so in the 1990s? Well, that is going to be very difficult for a couple of challenges that I'm going to explain. Is it because we're focusing on what is happening there being Ukraine, and the now, so war crimes, for instance? I know that in Canada there is, from your amendment, is related to gross human rights violations or violations of international security, if I'm correct. So there's that. Or we focus on the here and now. So we think about the corruption proceeds that have been stashed and currently are stashed in the apartment in Kensington. They're still having an impact on our economic and national security here in the UK. So depending on the why, well, actually, I put a couple of questions like here in terms of why we didn't follow the Canadian model, but I can answer these questions like in case somebody from the audience have them, but they are here for you to see. So to answer the question, okay, so we focus on a crime. We decide to go through the asset recovery model, we go through the asset recovery processes, then these are at present the different routes that we have. We have criminal confiscations, that is conviction based, so we would need, a proper conviction beyond reasonable doubt. We have civil confiscation that has a lower standard of proof on the balance of probability, so it's more likely than not that these assets are related to underlying criminality. We don't really have administrative confiscation, and then we have other venues that I'm honestly very interested in exploring, because I'm Italian and Al Capone was got, like, they got him through taxes, so I always think that taxation is quite of an interesting venue to follow. But depending on this, so these are the things that we have to keep in mind, and these are the criteria. We have to get to at least that standard of proof, if we want to go after a crime, if we want to go after proceeds of crime. So how do we do that? And is it possible to do that? That's a very difficult question, because at present, proceeds not just of the so-called oligarchs, but proceeds of corruptions, generally speaking, they're very difficult to confiscate for a series of reasons. Well, first of all, assets are held via complex multi-jurisdictional ownership structures. So if you talked about ownership, tracing the assets, that's the first stumbling block for even the most skilled investigator that you may know. And then, redirecting it and finding that ultimate beneficial owner is actually the individual that we're talking about that is designated, that's very difficult. We have very patchy or incomplete information sharing among different law enforcement agencies. These individuals operate transnationally. It's not that all the money is exclusively in the UK. So if I were, to ask other law enforcement agency, it's likely I will get a response, but it's not going to be timely. It's going to be very confused, and most of the times it's going to be incomplete. Then we have the fact that we have to gather evidence, and most of the times the evidence of that original corruption, especially when we talk about the oligarchs, is not even in uncooperative jurisdiction. In the case of Russia, it's a completely hostile jurisdiction. We're not going to get that evidence. They're not going to give it to us. Also because back in the 1990s, and this is why I talk about historic criminality, at the time potentially was not really a crime in itself. So how do you prove that corruption happened and to like it happened in the first place? And finally, and I think that this is also very important, the criminals have very legitimate and very extensive legitimate sources of wealth. So the assets are now mixed. They have been laundered so many times that distinguishing, when one ends and the other one begins, that's seriously, it's still a challenge nowadays. And this is the reason why in the UK, very few cases have been brought forward against what we could call kleptocrats or what we could call oligarchs. So considering this, what I've done is looking at every asset recovery mechanisms from Austria to Zimbabwe, so from A to Z, just to see if there was something that could be useful. And I found that depending on the challenge, some countries were doing better than others. Again, it's a very Orwellian way of saying all asset recovery mechanisms, generally speaking, they're not doing great, but some are doing less, a bit better than the others. And these are the ones that I have identified also thanks to different assessment by the Financial Action Task Force. So the idea is, if the problem is tracing the assets, if the problem is to provide, this link between the individual and the asset itself, then obviously mechanisms that reverse the burden of proof, focusing on the unexplained wealth of individuals, that is already helping and putting the odds a bit more on the side of law enforcement. Lowering the standard of proof below the balance of probability, which is possible in some cases, such as in the Pursuit of Crime Act in Ireland, that's another option. Focusing rather than on the crime, specifically on the general network that these individuals have set altogether, that's another option. And then I think that that's actually the two last that I think are very, very important. And one is looking at resources and specialism, and the second one is looking at what I said before, so the here and then the here and now. So the matter of resources and specialism, honestly speaking, all the countries that are doing better in asset recovery, it's because they properly resource and enforce their law enforcement agencies. You can have a very good asset recovery law, but if the law is not enforced properly, then it's just going to be a very nice piece of paper. And then the second part is, obviously, if we cannot look at that historic crime, then, and if it's so difficult to actually prove that money laundering is taking place, then let's look at the impact that this crime is having on our society and on our national security. Now, in the UK, specifically, illicit finance is now elevated to as an issue of national security. It was included in the integrated review both in 2021 and in the reiteration in 2023. So there is slowly that understanding that it is much more detrimental to our society and economic security and stability than we would like to admit, essentially. Some countries like Italy, I put here Switzerland just because they have a very interesting asset recovery law. They added a caveat that makes it completely useless, but I always think that without that caveat, it would actually be useful. But I think that the lesson here is more from to see the anti-mafia code in Italy that obviously focuses on a different type of threat, which is the one of serious organized crime. But what they do is that they look at the impact, the societal impact that mafia groups have on the country. And because of that affiliation of the individual and the affiliation of the assets to that specific individual, that's what triggers the whole confiscation process. And it has been tested multiple times in front of the European Court of Human Rights, and it has passed every single time, any test that has been brought. So what I thought, like looking at it now, even it's even more, interesting that the way that I approach it is obviously we see laws such as the one for the Italian anti-mafia code, we see the POCA in Ireland. All these laws are laws that were drafted at a specific moment of time when something big happened in that specific country. Well, right now we can say that something big happened internationally, which is suddenly we have realized that, Russian dirty money had been there for a long time, and kleptocracy is actually, we had a very open door in the back, letting all these flows of money in, undermining as well our democracy. In the meantime, election interference and disinformation is another one. So let's start treating this issue as such. Now, if I can manage to. Here we go. So I drafted a couple of recommendations these are the ones that I put in my paper, but then I added a couple of ones here as well in my presentation. So obviously looking more at societal danger and national security models as basis for confiscation proceedings. Reverse burden. I'm aware that I think is it British Columbia that recently adopted unexplained wealth orders, isn't it? So that is something that was quite interesting, because I saw that it was more following the UK model, which is a bit limited, but, focusing on unexplained wealth, focusing on reversing the burden of proof, that's already, it's never about drafting the perfect mechanism, but it's about putting the odds more in favor of law enforcement, which takes me to the third observation, which is legislation will only get you so far. You need to look at resources and coordination and political will to prioritize these issues. And finally, I put here some other things that are more. So obviously, when we talk about drafting something that would be, for asset recovery, this is not something that is going to happen quickly. I was very surprised when I saw Canada moving so fast. I know there was a draft, obviously, legislation there, so that probably helped. I don't think that if we are trying to do something that is sound and that is respecting every, due process concern, every human rights concerns that may arise, that will need, a proper think over of how we do it to create a mechanism that is going to even facing the challenges that are going to be brought forward by the oligarchs, because they will challenge. They're already challenging sanctions designation. Imagine the confiscation proceeds. So in the meantime, I put some short-term recommendations, which is enhancing information sharing between the different countries, mainly origin country and destination countries, ensuring better coordination mechanisms, because sometimes, again, even within one country, the different authorities do not communicate with each other. And then finally, and this is, and I'm going to finish because I think I spoke for too long, but it's focused on sanction evasion. Right now, we're seeing in the UK, we have actually proposed an amendment to the Economic Crime and Corporate Transparency Bill to impose a duty to disclose for any individual of their assets that they are held or controlled in the UK once they are placed on a sanctions list, but that backtracks 6 months prior to the designation itself, considering that we're seeing, a pattern of evasion. They're learning. They're learning from other sanctions regimes. Russia sanctions, they're not really the first sanctions that have hit. So focus on sanction evasion, impede for this money to be moved abroad and to move somewhere where they're going to be hidden. And yeah, I think I'm going to finish here, because I'm seriously looking forward to hear the questions from the audience. Thank you.
Thank you, Maria. That's a lot of food for thought, and you left me with more questions than answers, which is a good thing, because we'll get into the discussion and see perhaps some of the audience may have input. But before we get to the audience, I did want to turn to Professor Hampton and for some of your thoughts on Canada's asset forfeiture regime. Perhaps some reflections on what Maria has stated in her presentation, and I'll just throw some questions to you. Did we rush into establishing our regime? Is this what the Migration and Refugee Council envisioned when we were trying to do this initially? And how can we do better? And what are the challenges ahead of us? Thank you.
Well, thanks very much. And I want to really congratulate Maria on an excellent presentation that takes what we've been doing in Canada, puts it in a broader international context, and identifies some of the legal challenges when it comes to forfeiture of privately held assets in another jurisdiction. So perhaps just to give you a bit of background, the World Refugee Council began working on this issue back in 2018, and this was well before Ukraine happened. And it was very much in the context of how do you mobilize additional resources from kleptocratic regimes that are responsible for much of the forcible displacement that's taking place in the world to go beyond sanctions, to use those funds to help those who've been forcibly displaced. That was really the basis of our work. And we developed in a series of working papers that were written by eminent Canadians who have a very strong legal background, including former Minister of Justice and Attorney General of Canada, Alan Rock, who produced a series of papers for the council, working with others to look at this issue. And then Ukraine comes along, and it sort of supercharged both the debate around this issue and the work that's been done. Now, I can't speak for the government, but I think it's fair to say that the motivation here recognizes something pretty fundamental in what I would call the sanctions debate and literature. The initial motivation for putting individuals and their assets on a sanctions list is with the intention of eventually releasing those assets, returning them to their owners, if there is a positive behavioral change by the offending party or parties. I think it's fair to say, given what we're seeing, the tragedy unfolding in Ukraine, that we're well beyond that. The idea of behavioral change and using a sanctions regime to bring about behavioral change is there's a point of no return that has been passed there. And so, that raises the question, if you do have these assets, can you use them in a way to exert a form of punishment? Because that's really what we're talking about here with confiscation, punishment. And then I would call this divine justice, using those assets to help the victims of those who've suffered at the hands of the perpetration of major crimes. And so that's really, I think, the fundamental premise here is that one takes what are generally conceived as ill-gotten gains. I mean, that's how these people ended up on the list. Not every Russian is on that list, but there's a reason why some of them are on that list. And the idea is to repurpose them to help the victims and help the country that has been subject to invasion. Why do I say that? Because it's not business as usual, right? We're not applying the normal standards of what we would call asset confiscation. And the criminal bar is a high one, but I think it's fair to say in countries like Canada and the United States, I can't speak for the UK, law enforcement authorities can use civil forfeiture, which has a lower standard to confiscate assets, and administrative forfeiture, which is an even lower standard. I think what's also important is that there is legal due process here. It is not in the Canadian legislation. It's not just an executive grab. But to go back to the fundamental principle here, it's not business as usual. Secondly, we know that, and there's certainly enough anecdotal evidence that many of the funds that are parked around the world are Vladimir Putin's own monies that are being, I wouldn't say the word laundered, but he's using a shell game with his friends to park them around the world. So when we think of that oligarchic structure, it really is intimately, for all the reasons you mentioned, Maria, but this is an additional one that you didn't mention, that those webs and financial links run very deep, right into the Kremlin. You made a very important point at the beginning that I would just like to put on the table for discussion. Much of your presentation focused on private assets, but I think it's fair to say the debate is now shifting to state assets. And as you pointed out, that's where the real money is, some 350 billion, perhaps more. And by the Russian state, we're not just talking about the central bank holdings abroad that have been frozen, but the assets of state-owned companies, some of which, the oligarchs themselves are involved in. There's quite a wide range of Russian institutions that have assets that have been frozen abroad. And there, and I draw your attention to a very good piece that appeared in the Washington Post by Larry Summers, former Treasury Secretary of the United States, Philip Zelikow, and Bob Zoellick, former head of the World Bank. I think these are well-known names, where they essentially argued that there's a much stronger legal basis for states to take a run at those Russian state assets. There's an important precedent there in Iraq's 1990 invasion of Kuwait, where emergency powers were employed in the United States to, with the support of a UN resolution, and ultimately some 50 billion of Iraqi state funds from around the world were used to pay out the injured countries, principally Kuwait, in that invasion. The UN recently passed a resolution back in November, holding Russia for account, and that provides a further basis for confiscation of state assets in this case. Why does that matter in a Canadian context? Well, I have heard from reasonably reliable sources that there are not millions, but potentially billions of state-owned assets that are held in Canada. And, some of the numbers that get thrown around are, 5 billion or more. Those aren't trivial sums. So I think, we need to look not just at private forfeiture, subject to, all of the qualifications you mentioned, but also forfeiture of state assets. Countries can't do that alone, but a very important point you made, political leadership matters there. And I think, Canada, to its credit, and certainly to Minister Freeland's credit, has been seizing the bull by the horn, so to speak, and showing some real leadership here with the Canadian legislation that goes beyond SEMA and Magnitsky to refine that for forfeiture. But I think we also need to be looking at state forfeiture as an important part of that equation. And there again, Canada and others can take the lead, and it may be easier to do that. So that's enough for me, but thanks for a terrific presentation.
Thank you, Professor Hampson. And you do bring up a very important point, which is this, private versus state assets. And I wonder, Maria, if you want to say a few words on that. I would note that there would be a state sponsor of terrorism designation required for us to proceed with that. I wonder if that's the easier solution, why Canada has not yet designated Russia as a state sponsor of terrorism, which would open the doors for those type of seizures. But Maria, I welcome your remarks.
No, I mean, I will start by saying I try to steer away as much as possible from the state assets issue, mainly because my research focus, just generally speaking, is illicit finance. And so I entered into this conversation because I was looking already at those oligarchs. And so at some point, these individuals were sanctioned. So I was like, oh, okay, so we have to do something properly about these assets. I think that there are obviously very different caveats when we talk about state assets. I know that aside from the Iraq case, some people also mention Afghanistan as another example where state assets in some specific cases have been, managed to be seized, and then some have actually been used, for instance, in the case of Afghanistan, they have been used to compensate victims of the 9/11 terrorist attacks. So I think that obviously terrorism is potentially a venue. I haven't really explored how, like, what would be the reasons why, for instance, Canada or the UK haven't really gone into that venue. I think, up until this moment, I even think about the way that I was talking with some policymakers, and we were talking about, for instance, drafting some bills for the seizure of these state assets. They were always connected to the matter of reparations. And I think that just up until now, probably, there was still that idea that, when we talk about state assets, we will have to still have that conversation in the context of reparation of war. So probably now it's got to that realization that, well, first of all, Russia is not backing down, and second, we need to help Ukraine now even more. And so probably now there is that switch. I talked about political will, so I think that now it's even more likely that alternative venues are going to be explored aside from reparations of war, obviously. It's a non-answer, but
well, and it does come down to a political will at the end, and resources and finances, right, to do all this work, as you mentioned before. I am mindful of time, so let me turn quickly to Alana just to see if there's any questions from the audience or any questions that you may have. Alana, please.
Sure. We received a question from Nina about whether Maria's slide package will be made available. So, Maria, I'm not sure if you want to share that with us.
Yes, absolutely. And in my slides, there was also a link, obviously, to all the different organizations that were involved, and then there is a link to my paper, just in case you wanna read it instead of hearing me talking all the time.
Great. I know that this session is also being recorded as well for those who want to replay the presentation and the comments. We also received a comment from Senator Ratna Omidvar, and I'm going to read it so I don't interfere with the sort of spirit of her comments, but this is directed towards Maria as well. Senator Omidvar writes, "Please convey my appreciation to Maria for her excellent work. I am particularly supportive of her recommendation to encourage jurisdictions to work together and share information and act where possible in tandem. Further, I take her point that freeze and seize actions must be appropriately resourced. I hope to do my part to ensure that in Canada."
Yeah, this is just a comment from my side, but first of all, thank you very much. I really appreciate it. And second, I think that the matter of resourcing, it's not shiny, which most of the times when you talk to policymakers, they want to see a bill because the bill is going to make the headlines. Resources and specialisms, they don't often make the headlines. However, as I always say, it's going to be just a nice piece of paper and nothing else. We have, at least in the UK, we have some potential powerful asset recovery mechanisms. The fact they haven't been used, that is indicative not of the fact that the law is not good, but the fact that law enforcement is not properly resourced. And again, it's the same with information sharing. It's often very easy, especially from destination countries such as the UK, the US, Canada, obviously, to point the finger at those countries where corruption takes place, but the assets are then plundered and moved somewhere else. So if there is no communication, first of all, between the origin country and then the destination country, and then among the different destination countries, because as I said, money is stashed everywhere, then any else recovery effort is just going to be very minimal, and it's going to be the follow-up step, which is asset return, because we want to see that money return. So I think that that's actually much more of a priority than any new bill on oligarchs' assets. I'm not talking about the state assets part, because that definitely requires some new mechanisms. But most likely, if we're talking about kleptocracy and kleptocrats and corrupt individuals, resources is the answer, more likely than not. On the balance on probability.
We also received a question from Senator Ahmedvar. She asks, what thought is being given to using the frozen and/or seized assets as collateral or government guarantees to unlock private institutional investment in rebuilding Ukraine? So I guess in this way, they wouldn't be liquidated necessarily.
Again, these are mostly for state assets, but I know, for instance, that from the European Union, there has been some discussion about setting up trusts for, I think it's just the central bank assets. Whether this is feasible or not, I think that maybe Professor Hansen knows a bit more. But yeah, I see that he raises his hand, so I will let him answer.
There are actually a number of proposals out there to put private assets in what might be called an escrow kind of account to be used as collateral for reconstruction and rebuilding in Ukraine. And I think the idea there is that those funds would be released if the government of Russia were to step up to the plate with reparations, and that if they weren't, those assets would then be used to support reconstruction efforts. Some have argued that you freeze the assets or you put them in escrow or some kind of third-party holding arrangement, and then use the interest that's being generated by those investments for reconstruction. But Maria, I think, as you correctly pointed out, that's not going to be a whole lot of money, and it's going to be more symbolic than anything else. Is that a reason not to do it? Maybe not. But I think if you're really serious about reconstruction, and here's something that I think really, it hasn't been put on the table, but we're now looking at conservatively something like $600 billion for reconstruction of Ukraine. Arguably, that figure is higher. I mean, it grows by the day, as we know. Are taxpayers in Canada, the United States, the UK, going to be willing to step up to the bill to pay those bills? Do we hand that over to international financial institutions like the World Bank? And the short answer there is, I think, no. And so politically, I think it's a much more sellable proposition to say Russia's going to pay, and here's how it's going to pay if it's not going to write the check itself, because we're holding state funds and private funds, and we're going to deploy them unless Russia provides reparations. And that to me is a sellable political proposition. And it does require political leadership, but I think public opinion will move in that direction. We're already beginning to see it move in that direction.
Thank you very much. If there's any other questions, Alana, we can take maybe a quick one, but otherwise I think we will wrap up.
But sure, I just have one more. Maybe we can deal with this very quickly. And I think this one's for you, Alesia. Another question from a Canadian senator. This one's from Donna Dasco. For Canada to pursue state assets against Russia, are legislation or amendments needed? I think you kind of alluded to this earlier in your comments about the state sponsor of terrorism designation.
Yes, yes. For us to be, for Canada to be able to seize the assets of another state, that designation is required. And was done in the case of Iran, for instance. But without that designation, there is no legal mechanism to do so. So that leads us to kind of that discussion about if that's the easier route and holding Russia as a state accountable for war reparations versus looking at the confiscation of individuals' assets, which I think there's two discussions as well there, because Maria did touch on the whole national security and social impact aspects of that. So we do have to be mindful about. We are doing a lot with this asset forfeiture regime, and there's the why, as you said, Maria. There's a lot of whys, I think, and they do differ, right? This is just one why, is to help Ukraine rebuild, but there are others, and that are worth also discussing and considering. And maybe the regime and the legal framework would differ as well based on what is the purpose that we're trying to achieve. But I fully agree with you in that legislation is paper, right? So we have been focusing a lot on legislation, but I think in the UK and other countries, there's a whole system approach to fighting financial crime, and that's constantly being referenced, and enforcement and resourcing are just top of the agenda. Ihor, I will end it there. I think we've had a great discussion. I'm very grateful to all of the participants, and I will hand it over to you for your closing remarks. Thank you so much, everyone.
Well, thank you, Alesia. It was a very informative conversation and presentation today. Again, we'll have the slides and the recording available through the UCBA and the Ukrainian Canadian Congress. So thank you to everybody who stayed with us and participated and in the questions and as well in the presentation. So we wish everybody a good day and continued good work in this important topic. So thank you very much.